Hello and welcome to the Harlan Institute Ashbrook Virtual Supreme Court competition. This is the round of 8 and match number 3. We have Kevin Basili and Max Steinberg representing petitioners. And from Oregon, we have Eliana and Grace representing the respondents. And we will begin now with petitioners. You have 10 minutes whenever you're ready.
Mr. Chief Justice, and may it please the court. The 14th Amendment's broad promise of equal protection under the law makes clear there is no place for states to discriminate on the basis of race. Notwithstanding this command, UNC uses race as preference for certain students within its admissions process.
This court should reject UNC's practice and affirm the promise of Brown. The historical context of the amendment demonstrates it was passed to guarantee the law would be colorblind and no respecter of persons on the basis of race. Even though the framers sought to address the harms of slavery, their other actions such as the Freedmen's Bureau, Civil Rights Act, and Freedmen's Schools were race neutral in their text and application and served a remedial interest that no longer exists. Furthermore, this court's precedents as far back as Slaughterhouse recognize that this promise applies with fair and just weight in any question of construction, regardless of which racial group is harmed. All racial classifications are inherently suspect and demand strict scrutiny, as was affirmed in Adirond.
Grutter, while holding that programs like UNC's must be subject to strict scrutiny, was grievously wrong and must be overruled notwithstanding stare decisis for 4 reasons. Firstly, the university's diversity interest is not compelling because the supposed benefits reflect lessons of life not unique to higher education. Permitting affirmative action here while prohibiting racial preferences in virtually every other context distorts strict scrutiny. Secondly, Grutter is unworkable because the Grutter-Gratz doubleheader allows racial discrimination through winks, nods, and disguises, which courts are ill-equipped to scrutinize. At the same time, as Caroline Product states, once a government policy appears to contradict the Equal Protection Clause, as affirmative action so clearly does, there must be a narrower scope for any deference.
Thirdly, Grutter has perpetuated racial stereotypes, spawning a college counseling system designed to help Asian students disguise their identity to gain admission. And finally, Grutter itself determined that all governmental use of race must have a logical endpoint, and universities have been on notice for decades. Affirmative action's inability to eliminate its own necessity is proof of its failure, and therefore reliance interests pose no barrier to reconsidering Grutter.
Well, Counselor, let me talk a bit about stare decisis. In recent years, this court's overruled a lot of precedents. Just last term, we overruled Roe v. Wade. We overruled Planned Parenthood versus Casey. We overruled the Lemon Test. We overruled precedents regarding labor relations and public sector unions. Doesn't this court face a legitimacy crisis if every single time a new case comes to this court with new members, old decisions are just jettisoned?
No, Your Honor. So long as the court follows the 5-factor test that has been set out since Agostini versus Felton, which lists the nature of the error, the quality of the reasoning.
Yeah, but let's talk about Casey. Casey laid out some factors stare decisis of why Roe should be reversed, and then we reversed Casey, right? We said, no, they were wrong. So even the standards of stare decisis have been in flux in recent years.
I think that I understand your question, Your Honor. Insofar as Dobbs held that Casey's analysis of the stare decisis framework of Roe was incorrect, they were still applying a neutral set of stare decisis factors. It was not as if they were making up.
How does legitimacy factor in?
I understand the concern of the court's legitimacy, but the court's legitimacy is derived from getting the law right, not from public pressures. Public pressures can distort the law if justices are willing to bend into them.
I think Justice Kelso had a question. I'm sorry for interrupting you, Justice Kelso.
Yeah, actually, Dobbs didn't overrule the Casey theory of precedent. They just applied the factors differently. In Casey, they said, we think Roe is not grievously wrong, and we think Roe is workable. In Dobbs, the new majority said, we think Roe was grievously wrong, and we think it's unworkable. So they weren't applying the factors. They weren't changing the factors. They just had a different take on the factors.
Yes, I'm sorry.
And so my question is, in this case, which of those factors do you think that the Grutter analysis for me is grievously wrong? Do you think it's unworkable in practice? Do you think it's inconsistent with related doctrines? Under the factors they've been using in Agostini and in Casey and recently in Dobbs, it's all the same factors. Which of those factors do you think really are the ones that call for overruling Grutter?
Your Honor, I believe all 5 factors call for overruling Grutter, beginning with the nature of the error. The error of Grutter was previously misinterpreting the 14th Amendment, saying that an amendment which mandates equality in fact permits states to discriminate on the basis of race in certain contexts. So clearly there is a grievous error.
Well, let me stop on that one. I mean, for the last 100 years, there have been examples of race discrimination this court has upheld. And certainly since 1978 in the Botke case in education, we said that you can use race in some contexts if you can meet a strict scrutiny approach. So it's not really inconsistent with the last 50 years plus of doctrine. The Supreme Court has never adopted the view that the 14th Amendment is pure colorblind in every context. We allow a lot of affirmative action in the military, in businesses, and in other places. So I sort of disagree with your analysis that somehow it's that use of race is inconsistent with the whole sort of last 50 plus years of Supreme Court doctrine.
Let's go back 100 years, 150 years, right? You mentioned that the framers of the 14th Amendment, that generation, enacted the Freedmen's Bureau Act in a remedial fashion. Let's say you're right. Maybe we agree, maybe we don't. Does that lock us in? In other words, if they only enacted remedial legislation in the 1860s, does that mean that we can never depart from the original practice? So we sort of frozen in time based on what they chose to do? I mean, indeed, in the 1860s, everything was remedial. We just had a civil war. They had to fix stuff. But experience has shown that remediation perhaps was not adequate and that other interests, such as diversity, might be justified. How do you respond to that?
The solution to remediation not being adequate is not to have affirmative action exist.
But are we locked into what the framers, what the Reconstruction Congress in the 1860s, are we locked in forever? Does that bind us indefinitely?
Yes, petitioners submit to the court that the original meaning of the 14th Amendment is binding on the court, yes.
Is that practice the entirety of the original meaning? Can original meaning go beyond? Maybe they had options A, B, and C, and they only chose option A, right? Why are we locked into only the option they chose?
Your Honor, because of the context of the 14th Amendment, it's clear the framers were attempting to eradicate racial discrimination from the law. If we look at black codes and Jim Crow laws, this was the primary target of the amendment. And so it's reasonable to assume that racial hierarchies were detested by the framers. Now, with respect to various options for rectifying past discrimination, there was a unique remedial interest in the past, as you mentioned, due to the recent Civil War and slavery, and that doesn't exist today. It's true that there may be some disadvantages that minorities face, but that does not serve as a compelling interest.
But I want to get to this one point. Let's assume that in the wake of the Civil War, they were focusing on remediation. I'll agree with that, right? Because we just had this huge Civil War. We had a lot of things to fix. But why is the original meaning frozen, that is locked only that one context what they did? Why can't the original meaning extend also to things beyond remedial measures for other ways removing disabilities on an educational context? That's why you might need diversity in the classroom. Why as good originalists, we can say, yes, remediation is consistent with what they did, but there might also be other things that are consistent. Answer that question, please.
I think as this court's precedents demonstrate, the remediation interest fits within the strict scrutiny framework.
It does, but why is it limited to remediation? Why can't we do other stuff also?
Your Honor, we're limited to remediation because a race-conscious policy such as affirmative action is the exact kind of preference that the 14th Amendment was targeting.
So you think, so this goes perhaps to Justice Thomas's a separate writing in the Fisher case. Do you think the sort of segregation at issue in Brown is comparable to the sort of affirmative action policies used in Texas and Michigan and elsewhere?
Yes, we do, insofar as they sow racial division and they teach students a lesson that race matters. And that's a lesson that they take not with them, not only when they're in the classes at universities, but into the real world once they graduate. It teaches a lesson that can never, that is so potent in students' lives, that exists far beyond the university campus, that race matters.
And let me ask you this in your final minute here, and then maybe you come back to it in rebuttal. Let's say we disagree with everything you just said, and we think diversity is a compelling interest that in a strict scrutiny could satisfy the Equal Protection Clause. do you think Grutter should still be overruled because the way in which it applies it is unworkable? Or is your argument just totally based on it's just not a compelling interest?
Yes, Your Honor. Grutter was a fundamentally unworkable case. As Justice Ginsburg's dissent in Gratz described, the double header in those cases allows universities to continue quotas and plain racial discrimination through winks, nods, and disguises.
So if as a factual matter, do you think if we overturn Grutter, the racial composition of UNC is going to change?
I think that as we demonstrated to the district court, if UNC was willing to adopt the numerous plethora of race-neutral plans that we propose, simulations 3A and 11, as well as the modified Hoxie plan, there'd be a very minimal decline in underrepresented minority enrollment.
Okay. Justice Liu, I'm sorry, do you have another question? I didn't mean to interrupt you.
Well, I'm just wondering what you have to say to all the racial minorities out there who, if they start seeing a precipitous decline in our elite institutions, what do you have to say to them?
Give me an answer. Go ahead.
Your Honor, the fact of the matter is the Constitution prohibits this affirmative action. And if what the Constitution demands may have this side effect of decreasing the admission of underrepresented minorities, then there's not much more to say than this is the demand of the Constitution.
Okay, very good. Thank you, Counselor. Respondents, you'll have 15 minutes. Whenever you're ready, you may begin.
Chief Justice, may it please the court. I am Eliana Choi, and I'm here with my co-counselor, Grace Wilmuth.
This court should find that the University of North Carolina's admissions policy is consistent with the U.S. Constitution for the following reasons.
First, affirmative action is consistent with the intentions of the 14th Amendment and other legislation created to combat racism.
Second, affirmative action has been upheld in various cases, including Bakke, Bollinger, and Fisher. And finally, Proposition 209 in California reveals that affirmative action is still necessary, and banning it now would have devastating consequences.
First, legislation passed in the 1860s, including the 14th Amendment, was very explicitly established that its intent was to protect the rights of minorities. When Thaddeus Stevens, chair on the Joint Committee on Reconstruction, introduced the 14th Amendment to the House, he stated, "Whatever law protects the white man shall afford equal protection to the Black man." This speech very explicitly stated race and acknowledged the difference in treatment between the two races, showing that 14th Amendment should be used to protect the rights of Black people, since it was very different from the rights of white people. Additionally, the 14th Amendment has been used to protect other races, such as Chinese people in 1886, Yekwo v. Hopkins, and even applies to other minorities, such as gay marriage in Obergefell v. Hodges.
Additionally, affirmative action is a race-based classification that is under strict scrutiny because it is both narrowly tailored and has compelling government interest. It's narrowly tailored because there's no other adequate policy that would allow for a critical mass of minority groups. And affirmative action is a necessary mechanism for extending equal opportunity to students that have been.
Well, let's talk. I mean, you mentioned protection for Asian Americans. I mean, in this case, there's been significant litigation, amicus briefs by Asian American groups saying that, they're being discriminated against. In fact, I think your friend on the other side said that Asian American coaches try to de-Asianify resumes and college applications. So, how do you say this is consistent with fighting against Asian American bias?
Well, first of all, I think to group all Asian Americans into one category is kind of like forming stereotypes when
Aren't you grouping them that way?
Well, I think if the college admission process was completely race blind, it would negatively impact Asian Americans.
Because then they would.
But isn't the experience in Prop 209? You cited that earlier. Didn't that increase the number of Asians who were admitted?
It did increase the number of Asian Americans who were admitted in the California system. However, but the issue in Proposition 209 was primarily focused on Hispanics and African Americans who felt underrepresented, and didn't have equal opportunities, and it also negatively impacted them later on in graduate programs such as medical school, law school, and business school.
So are you saying it's okay to decrease the number of Asians because there's too many Asians based on their race in order to increase other groups that are to increase an underrepresented group, don't you have to decrease a purportedly overrepresented group?
I don't think we can look specifically at like the percentages and like quotas of like racial groups. And since the like UNC's policy is holistic and they have over 40 factors they consider in admission, I don't think there's a way for an applicant to prove that like standing in that case that there was like another group of another like person took their spot purely because of race.
Well, let me ask you this. If we gave the petitioners what they wanted and overturned Grutter, would that change the racial composition of your class, do you think?
Yes, I think so.
Okay, so that means the race consciousness is doing something, right? It's having some effect in increasing certain groups that you're trying, which is what you're trying to get at, right? I mean, if it didn't, then if we eliminated Grutter, you would have no hit to your diversity racially, right? So I think that answer kind of fits into your overall argument. But then in order to increase representation of certain groups, aren't you decreasing certain other groups based on their race?
Well, the purpose of affirmative action is to create diversity and inclusion. And as of now, Black and Hispanic households only hold 2.9 and 2.8% of the wealth, while accounting for 15.6 and 10.9% of the United States population. So we believe that the goal of affirmative action is to reverse this and create the pipeline of diversity into the middle class that will create more equality and equal opportunities for all groups. Because it will also, affirmative action
by reducing overrepresented groups. Is that right?
It will reduce overrepresented groups and create more equality for everyone because there will be more diversity and more viewpoints represented on college campuses.
Okay, and why is that? Because for this to be constitutional, it does have to be that having that diversity in the student body is a compelling interest to satisfy strict scrutiny. Why do you think it's a compelling interest? Why are you willing to sort of decrease certain groups from getting in and increase others? You're doing that in order to get diversity. Well, why is that so important?
Well, first of all, and Justice O'Connor stated in Grutter v. Bollinger, diversity creates educational benefits. And Justice Powell said the nation's future depends upon leaders trained through the wide exposure to the ideas and mores of students as diverse.
Okay, and why is that true? I mean, just because two justices said something doesn't make it true. Justices say things all the time, in majority opinions, in dissents, and they say different things, and they both can't be true at the same time. So what is the evidence that, in fact, Justice Powell and O'Connor were right in their analysis of diversity's impact on education?
Okay, well, we have three main reasons why we think it's important for diversity on campus. The first one is to ensure that minority students don't feel isolated on campus and they don't feel like tokens or spokesperson or spokespeople for their representative group. Second, a critical mass would provide educational benefits of diversity for all students. And there's extensive research that indicates that a diverse student body does provide the opportunity and benefit students of all groups. And by reaping those benefits, it requires more than simply having the existence
And how does it achieve those benefits? I mean, what do the studies say the benefits are?
Because it increases diversity and there's more viewpoints that are.
Okay, yeah, and why is having more viewpoints in the classroom an important, compelling interest for education?
Because it reduces negative stereotypes and promotes diversity.
Yeah, but you're just saying diversity is diversity, but that doesn't tell me what the educational benefit of diversity is. Why is having a diverse student body educationally better for all students?
Well, I believe it's important to hear from many people's opinions, and all of these diverse students will have a diverse range.
So then why aren't you trying to get diversity of viewpoints, right? Why do you say stereotyping is bad? Why do you presume people of different races will necessarily provide different viewpoints? It's a stereotype.
Wait, what you're saying that different viewpoints will
why do you presume that people of different races will provide different viewpoints? That's a stereotype.
Well, people from different races and different educational backgrounds and just diversity in general. You're bringing together people from
But
different.
you're not searching for diversity of thought, you're searching for diversity of skin color. And you presume that different skin color will yield diversity of thought.
It will yield diversity of thought
It's a
because
stereotype that you're assuming, right? It's assumption. It's not always true. What if you have, in a wealthy neighborhood outside of, Portland, a black family and a white family live next door to each other. They hang out all the time, the exact same world experiences. Why do you presume the wealthy black student will have different experience than the wealthy white student?
well, we believe that affirmative action is not just race-based. You're also looking at like wealth and
I think you rejected socioeconomic as an alternative. Your friend on the other side wants you to use socioeconomic. You don't want to use it.
Well, I think in the past, like affirmative action has been upheld because it's been effective.
Well, I don't know if that's why it's been upheld. I think a couple of justices said that, but maybe a quarter century later, we realized that it hasn't actually even achieved. I mean, you say you haven't achieved your goals with using as much as you want. So I don't know if that's effective, but the point is you're still stereotyping, right? You still presume that if we get people who look different, they'll have different experiences, and that's an assumption. It's a stereotype.
Well, UNC's admission policy is holistic and they consider a lot of other things. And the admissions
Checkboxes, right? You only have a race checkbox. You don't have a checkbox for anything else. That's the only checkbox you have. Why do you have the race checkbox?
they use over 40 different, they look at over 40 different parts of like.
How is the checkbox used? That seems like a very important thing that you have specifically. You can sort people by that one factor.
But UNC's applications or admissions policy is holistic, and they'll only consider race as a factor among many other things, including essays and like information about people's like extracurricular activities and essays about their backgrounds and experiences.
Students' applications aren't limited to a single checkbox. They're considered holistically with everything else in their application, and they're not solely determining admission based on.
Let's go back in history a bit. So your friend on the other side responds that the Freedmen's Bureau Act and other sorts of laws like this were remedial in nature. And he's probably right about that, right? In the case like Adirondack and City of Richmond, the court said that remedial measures are possible. Isn't diversity-based racial classifications like Grutter, isn't that a deviation from this court's long-standing precedents?
I think affirmative action at its like core purpose is still like to like protect and give more like opportunities to minorities.
No, but I'm asking you as a matter of precedent. Aren't the decisions governing affirmative action, doesn't that deviate from what this court said about remediation? Isn't that sort of a departure?
I think affirmative action is actually similar to the legislation passed in the 1860s.
No, I know that. Let's assume it's remedial, right? I know you can draw analogies, but isn't saying diversity is a compelling interest, doesn't that deviate what this court has said in the remedial cases?
Could you clarify that?
Are you familiar with the remedial cases like City of Richmond and Adirondack?
Yes.
Okay, so in those cases, why was use of race compelling? Or why was use of race not allowed in those cases?
Well, in Adirondack, the Supreme Court held that all race-based classifications are subject to
strict scrutiny, right? And what about City of Richmond?
I'm not familiar with that case.
It's a similar affirmative action case based on a history of discrimination against a group. I guess my question is, yeah, there are a lot of Supreme Court cases that say you can do race-based affirmative action to remedy prior discrimination against that racial group. That's clear. Here in Grutter, you're saying, well, we have a different compelling interest of diversity in education. So, I mean, you could have two compelling interests. I mean, there are lots of compelling interests that are used in various contexts in constitutional law. So there's not only one interest is always compelling. So isn't your argument that, well, yeah, the remedial thing could be compelling, but diversity in education, student body is a separate compelling interest that just applies in that context, just like a compelling interest for national security applies in cases involving the military.
the compelling interest. Sorry, go ahead.
Go ahead.
The compelling interest in the affirmative action cases is diversity, because as Justice O'Connor stated in Grutter v. Bollinger, it creates educational benefits from student body diversity. And the nation's future depends upon leaders trained through wide exposure to ideas, and more students in a diverse nation will create more.
She also said she expected in 25 years that the use of race will no longer be necessary. So how do you respond to that?
Well, we can't predict the future, and I don't think it's good to set like a time limit or a quota on affirmative action, as that would go against some of like past legislation.
But didn't she talk about all of the problems that this is inflicting, its own discrimination, that's really in tension with the Equal Protection Clause? So she's acknowledging that every year you're doing this, there's also people being hurt by it, and that's why she and the majority felt they had to say something about it. We can't do this forever. I mean, are you basically arguing we should overturn Grutter and say we should be able to use race indefinitely without ever having to revisit it?
Sandra Day O'Connor talked about the purpose of affirmative action, that it was limited to 25 years because the purpose was to create a pipeline of diversity into the middle class, which we agree with that. We think that the purpose of affirmative action is to create that pipeline of diversity into the middle class, but we are not yet there yet. And that's why we need it longer than the 25 years. We have not yet reached where we need to be.
All right, well, counsel, what happens if, let's say, in the 25 years from now, you come back to this court and you're still saying we need affirmative action? I mean, is it really affirmative action today, affirmative action tomorrow, affirmative action forever? Is that really our rule?
In the future, we hope that it won't be necessary, but like as of right now, there's still a wide disparity between like students who have been whose races have been traditionally oppressed and students who haven't.
And additionally, as we mentioned earlier, Black and Hispanic households only hold 2.9 and 2.8% of the wealth, while accounting for 15.6 and 10.9% of the
Why don't
population.
you use socioeconomic status that your friend on the other side wants? Wouldn't that get to the disparity in wealth?
Not necessarily, because a lot of the disparity in wealth is due to past racism.
But again, are you claiming remedial?
Yeah, that's your real problem, isn't it? That your argument really is, the affirmative action we're doing now is remedial to try to make up for past discrimination that has left Hispanic and Black families with less resources. We're really trying to remedy that. But the problem is, what Justice O'Connor said in Grutter is, well, no, we're not remedying anything. We're having diversity as a separate interest. And you're sort of stuck with the diversity that she gave in Grutter as the reason for it. Whereas, as you sort of say, the real concern here is to remedy the prior discrimination that's put these groups at a lower economic status. And so it's kind of a catch-22 for you.
You can answer that question, please.
Yeah.
Go ahead.
We think remediation and diversity kind of go hand in hand.
Yeah, I don't have the precedent supports that, but I appreciate your answer. You're out of time, but thank you very much. We have 5 minutes now for the petitioner, please. All right, whenever you're ready. May begin?
We'd like to begin by addressing a few questions we didn't get to fully elucidate our answers to during our first 10 minutes. So if everything was remedial in the 1860s and 70s, how come the court would be cabined to the remedial interest today? If the court weren't, there would be a debtor and creditor race in this country forever, a proposition Grutter itself expressly rejects. The universities can't assert a remedial interest because its preferences that currently exist favor individuals whose families have no connection to slavery or Jim Crow whatsoever. So there's no nexus.
Well, wait a minute. Let's stop right there. Virtually every Black family in the United States today is affected by the legacy of slavery and Jim Crow. They all have suffered the intergenerational effects of the immense poverty that was imposed upon them by those practices. It didn't just magically disappear in 1954 with Brown. I mean, it just didn't.
I think that's correct, Your Honor, but UNC's plan also would favor an immigrant family who came here just 2 years ago, or a Hispanic family that came here just 6 months ago. So there's no nexus between past societal discrimination and UNC's plan on its face.
Well, counsel, I'm sorry, go ahead, Justice. Sorry to interrupt.
Because the distinctions that UNC makes are so unspecific and broad, they do not give a clear view of who has actually been discriminated against. And as my colleague explained,
let's say they shifted their policy and the admission essay had one question, right? Have you been discriminated against? That's the admissions essay question. And that was the basis on which they admitted people. Would that be okay?
So long as responses to that question would be viewed just as favorably, regardless of whether the discrimination was racial or otherwise.
I think as a realistic matter, we can presume that most white people will not have any genuine to discuss in that box, and a lot of people of color will have something genuine to discuss in that box. Wouldn't it just be a proxy?
Insofar as that would be a race neutral policy, but designed as a proxy for race, that would be subject to the Arlington Heights framework, which the court does not have to deal with at all in this case today. Regardless of how the court resolves this case.
What if the courts ask a question application, are you descended from a slave?
I think insofar as that is a discrimination on the basis of ancestry, that according to this court's precedents is viewed as the same as a discrimination on the basis of race. So that would be a much more clear proxy on the basis of race.
All right, may continue.
Furthermore, Your Honor, with respect to what we would say to students if diversity declined, Grutter states that affirmative action programs must be the exception to the rule of equality. And the fact that Grutter has failed at this mission is not a reason to extend it. Further, the modified Hawksby plan demonstrates that there will be comparable diversity. As UNC stated in its amicus brief from one, a race-neutral plan would actually have led to a 1% increase in diversity by their own metrics.
When asked why diversity is important, respondents' counsel responded that having a diverse student body is an interest in itself. That rejects the demands of strict scrutiny. Their assumption that different skin colors result in diversity of thought is based on stereotypes that poison.
But counsel, do you deny that? Okay, so I get it. Stereotyping is bad, but in the aggregate, right? In the aggregate, if you're admitting hundreds of, let's say, Black students, in the aggregate, won't they provide something that hundreds of white students will not provide? I guess on a case-by-case basis, there might be, exceptions, but in the aggregate, isn't there some benefits to be obtained? Is O'Connor just wrong altogether?
Your Honor, considering that in the aggregate still requires a racial stereotype to assume that a large number of Black students will take a certain point of view.
Isn't there socioeconomic data and briefs that can stack a mile high proving that you're wrong?
If past societal discrimination has resulted in lower wealth for different racial groups, as respondents making their argument, a socioeconomic advantage would be sufficient. That's exactly what we propose.
But why? But all the
But that's what, I mean,
Just
let me say this. You say it would be sufficient, but certainly California, which has been under a no race-based affirmative action mandate, says it isn't sufficient. They're trying to do socioeconomic affirmative action in California now, but it has changed the composition of their elite universities in a way they think is negative. And now Michigan as well. Michigan's under a constitutional amendment. They can't do race-based affirmative action anymore. My guess is they would argue that it's changed the composition of the University of Michigan Law School. So how do we know that socioeconomic would be good enough when states that have to use it now are saying it's not good enough?
I think if you look at the 2021 incoming class to the University of Michigan, admissions officials said it was their most racially and ethnically diverse ever. So it certainly has not been a problem in Michigan. And additionally, the basis for why the university rejects our plan is that it would not allow for their current actual levels of diversity, but that would amount to a quota, which Bakke squarely forbids. And determining, it's a question of at what level of generality do we determine diversity, right? And
okay,
as far as universities rely on broad and arbitrary racial groups, that does not suffice.
Thank you so much, Counselor. Very good. All right, the case is submitted. If the other team please come back on camera, please. We'll give you some feedback now. I want to commend both of you, both teams. If you notice, we sort of leveled up. We increased the intensity of the questioning. I'm sorry, we increased the interruptions. It was very much designed to not let you get out a damn sentence, and you didn't often get out your sentence that you wanted to. We were trying our best to simulate what a very hot, even arrogant bench might do, especially if there's hostile questioning. Now, the Supreme Court, at least, the conservative judges might give hostile questions to one side and liberal judges to the other. I think we tried to give hostile questions to both sides to simulate. Maybe Kelsey's laughing, right? We try, at least I try to make the experience as unpleasant as possible for both sides. I thought you did very well. What was very useful was that you tried as best as you could to pivot from a point of obvious weakness, which I pointed out, to a point of strength. But we didn't let you. We tried to pin you down. And then eventually, sometimes when we pin you down, you're going to have to give a yes or no answer, right? You may not want to give the yes or no answer. You have to. And then once you give the yes or no answer, we're going to pounce on you. And you know we're going to, right? Which is why you don't want to give it. And I sort of describe it as like a boxing match where sometimes you watch a boxer, he knows he's gonna get punched, but then that sets up a counter punch, right? He just has to take the punch. It hurts, it sucks, but then you sort of come back at them. We also give a lot of policy questions about the court's legitimacy and this question about stereotyping different people, different race. I mean, these are not questions that are really about law. But when you're at the US Supreme Court, these are kind of second order questions of higher magnitude. How do you actually, what are the implications of ruling of this gravity? And this is something we're really trying to pin you all on. And I thought you were all strong. I thought you handled our attacks well. And you know, I'm very proud of you all. It's just, it's, I have to keep in mind, you're a bunch of high school kids. You're not in law school. Even though I treat you, I'm sure Kelsey will agree, this is how I would treat my law students, exact same way. I didn't pull any punches. This is what you get in 1L. So congratulations to you too. Randy?
Yeah, again, you thought you guys did great. See, the problem on your respondent side is, and it's where you are, is that the court has abandoned sort of remedial justifications for race-based affirmative action, which was the justification originally back in the 1970s and 80s. The minorities have been excluded from law schools and medical schools, et cetera, and we're trying to remedy that. The Supreme Court from Grutter on really has shifted to this diversity rationale, which is independent of the remedial that justifies most affirmative action that's based on race. And yet you have a sensible argument. You quoted the statistics saying, yeah, because of prior discrimination, these minority groups have less economic resources they otherwise would have, and we're trying to create that pipeline. That's an important pipeline, and that is remedial. I mean, that really should be the justification for race-based affirmative action even today, is that you're doing it remedial to create a pipeline because of the historical discrimination in the past. But the Supreme Court's that's not what they say. From Grutter on to Fisher, et cetera, they're putting it all on diversity, which is, if that's a compelling interest, that could extend indefinitely into the future. You would never get rid of it, which wasn't really the original intent. So you're sort of stuck with a court that's given you a reason for affirmative action that is, as you got questions about it, a lot harder to defend than if the reason still was argued to be remedial. And I thought you did a good job. You did the best you could. And you built in the remedial part of it as part of it. We're trying to build a pipeline. You tried to connect that pipeline to your diversity argument, which is exactly right. That's exactly what you should be doing. So I thought you were very clever to do that. And you came back to it a second time right at the end to sort of underscore it. So I thought that part of the argument was well structured in terms of how I think about these issues. But it leaves you with the kind of weakness that then the other side can beat you up on about, well, but except for remedial stuff we're fine with, but it's just, it's using race beyond that. The problem is a problem with the colorblind Constitution. And so, yeah, the petitioners got them all the arguments they make on their side about that, which I thought you guys did a pretty good job on that. Occasionally, I think you got a little bit overstated how much colorblindness really is demanded by the 14th Amendment. But when we questioned you, you sort of pulled back to a defensible position. So I thought you did a pretty good job when you got questions about it. Well, isn't this way, about pulling back to sort of defend sort of why Grutter should be overruled in the educational context because it's inconsistent with a colorblind Constitution and it's not really remedial. So I thought all you guys did a tremendous job. It's just, there is this sort of problem because of the way the Supreme Court and the way advocacy groups, again, the left has really put it all on diversity and inclusion now, that they haven't really pushed the argument about remedial, the intergenerational effects of it. And to me, politically, that's a mistake. I think they should have been pushing all along that this is all remedial because the legacy of Jim Crow, slavery and Jim Crow, still continues today. But they've, that's not the actual political climate. It's not what the Supreme Court says. So you're sort of stuck with those arguments, and there you go. That's all I have to say.
Thank you, Corey.
Yeah, I thought you guys did a great job. I punched you guys pretty hard, but that was because I felt you guys could handle it and take it. And I think you guys did a good job. I think the lesson here is, like, unlike other courts, like in a trial court or even in middle court of appeals, you get these like U.S. Supreme Court arguments, and this is a case where there's no clear right right answer, like as a sort of technical legal matter. I mean, it's the Supreme Court's precedent is kind of murky, ambiguous. It has language that sounds strongly in support of these policies, and then also in the same opinion, stuff that sounds very negative. So, I mean, the best you can do is just kind of find your best points. And in particular, at the U.S. Supreme Court level with a case like this, I mean, it's not like you're not actually having like a dialogue where, I mean, the justice is saying, like, I was trying to play gotcha like a cable TV news person, just throwing out the arguments. I'm not asking you for an answer. I'm just making a statement. It hardly even has a question mark at the end of it. But sometimes justices do that. They're either talking, because in a court of 9, they're talking to each other to try to set the landscape of the conversation they're going to have in private later. Or, especially with the live stream today, they're thinking about the media, like, what do you have to say to the people, out there? That's kind of the question I asked the petitioners. And so that kind of stuff, I mean, there's nothing you can do other than sort of on some quick level answer it and then try to find the next best point, throw back some language from one of the court's precedents. It's always good to quote precedents because I'm just saying what you said. I'm just reading from your own writing, right? But try to find something good to pivot to move away from that. But that's just hard. I mean, there's no way to like handle that other than maybe, like Professor Blackman said, you just have to take certain punches. And I tried to find some of the points that you really don't have a great answer to, and just put it there. And then you guys just have to do your best to move back to the framework that the Supreme Court has said that supports your argument. But I think you were both very poised and did a good job, which is why I was trying to push those really argumentative questions at you. I thought you did a great job.
Yeah, with respect to, I know you asked the question of what do you say to minorities if diversity goes down after overruling affirmative action? I guess I was a little, I'm not sure how my answer came off to you guys. I thought the only real thing to say was all you can do is just say that's what the Constitution demands is ending affirmative action. I'm not quite sure if there was a different way to approach that, but.
Yeah, I mean, I thought especially because I snuck it in there at the end, it was kind of a painful ending for you. I mean, I thought the answer wasn't great, but once you look at my amicus brief, you'll see I've argued the position that you guys are arguing, so I kind of know the questions that hit the hardest on that side, and I think probably the answer was some factor of like, think of the people who are being hurt by the policies, right? I mean, what are the Asians or the students who are, something like that. But there's no real perfectly satisfactory answer to it. I mean,
and the answers you gave is sort of consistent with the Supreme Court, because like in the Second Amendment gun control cases, their argument is the Second Amendment requires individuals to have the right to own guns, and they don't care if the data is all going to show that there's increased crime in the streets because more people are carrying guns around. They just say, well, that's irrelevant. That's what the Constitution demands. That is the way some of those justices think. And to me, it's just outrageous they think that. But that is the way it's increasingly in some of the doctrines. They're just saying, we think this is what the Constitution demands. And if it leads to a horrible result, we don't care. Amend the Constitution. If you don't like it, amend the Constitution. It's sort of their response. But it is kind of heartless from my perspective.
You do have
you have to point out the harms caused by the policies, right? The stuff like O'Connor might have said in Grutter, right? It's also you're hurting some people to help other people, something like that.
Yeah, I mean, so on the point of knowing your bench, you made a lot of points about originalism. I think that's actually a prudent move where you're arguing for the current Supreme Court. If this was 30 years ago, I would say you were committing suicide making those sorts of arguments.
Oh yeah.
Today, I think that you sort of know your bench. And I think even the discussion of Dobbs and Casey and the stare decisis, you have to know the majority of the court just voted to overrule Dobbs, just overrule Casey, not even a year ago. So I think you have to just be cognizant of that. Let me just give some style advice. This is sort of neither here nor there, but when you're on Zoom, look at the camera when you're speaking. I noticed Max, your eyes come out like this. You did a lot of this stuff, and also Liana, your eyes come out like this, like this. When your eyes move around, it sort of breaks eye contact. And this is something that advocates have to learn over the Zoom era, to actually keep your eye focused on the camera. One trick that I use is my camera is immediately above the screen. It's not like far away. So I'll be looking right at the camera. Unfortunately, looking at the screen doesn't help you because we don't know what you're looking at. We know you're looking at the camera. So try and keep your eye contact. Eliana, this is something you work on long-term. Use the word like a lot, almost that was noticeable. I'm sure you'll go back and listen to it. So it's hard to sort of eliminate those crutches. I took diction lessons for about 2 years to try and break some of my crutches. I did a lot of that was my crutch. And so if you want to get into the more advocacy space, you have to be aware of some of those crutches. Also, I think for both teams, when we come at you hard, it's very natural that you speed up. And the reason why is when you're calm and composed, you can focus on your pacing, right? You know you're speaking, you can be composed. But when we throw a bomb at you, you can't think about your pacing anymore because you're like fight or flight, right? You have to think of an answer quickly. And when you're thinking of an answer quickly, you drop your cadence, you drop your pacing, and sometimes it speeds up. You start breathing a little more heavily. I mean, it's not big, but I noticed it. Like it happened a few times, and it's something very subtle. And I'm speaking to it at a very high level. It's not advice I would give usually, but you're so good if you can sort of work to just take a breath, right? I know it sounds crazy when Corey or Kelso or me, whenever we ask you a hard question, go, just take a quick breath. It's half a second and it will calm you down. Trust me, it works, right? It'll seem like it's forever, but just a slight pause, even half a second, will settle yourself. Then you go into the answer. If you jump in right away, you go and then you may say something you regret and that you don't want to say. And again, this is high level advocacy advice I'm giving you because I think you guys can handle it. But you did very well, and I don't want to take away from your hard work and your obvious deep preparation. Do you have any questions for us that you want to ask either about the competition, about law school, or about whatever else?
I guess my question is what is the process of filing an amicus brief at the Supreme Court?
Corey, you want to do that one?
You got to find an amicus who's a person who's technically the party. So like I'm the lawyer, Professor Bernstein's the amicus. So he has to approve everything. And then I think at the Supreme Court level, they may have gotten rid of the rule. We have to ask for permission for both sides. It's just kind of a thing where people usually say yes. Or even if they say, we don't give you permission, you just file it anyways and ask the court for permission. So the court was like, well, maybe we should just get rid of that. There's some deadlines, like the timing. You just look it up on the rule on the Supreme Court's website. But I think it comes after your side, the lawyer for the actual party has filed, you then file your brief in support of them. You can also sometimes do this thing where it's like an amicus brief in support of neither party, where you're technically not advocating for either side. And then you just want to try to think of something to say that is actually going to be helpful to the court instead of just like you want to do a press release to say I filed it. I do try to actually say something more detailed, or that the parties didn't quite get to, or it was kind of more of an ancillary point that they didn't have space for, but you're actually contributing to the dialogue in some way.
Yeah, I'd encourage you to pull up the amicus brief that Corey did for Professor David Bernstein, who was actually my common law professor. So we're all connected in the vast right-wing conspiracy, as it were. But to your point, Eliana, that we're lumping all Asians in together. Yes. And Corey's brief discuss how various Asian groups, was it Pakistanis, or Afghanis, which was the one that didn't quite fit in, that were
well, like South Asians, and then the Pacific Islanders have been disaggregated from Asians for kind of advocacy reasons.
Yeah, and I think it was
I'm trying to be neutral. I've had my my positions, but I've also, because I've been listening to so many different people argue this case, I'd like to think that the positions I've taken, I don't want to let the merits of the argument detract from what's ultimately like the other kind of criteria on the rubric that are sort of just objectively as sort of a speaker, whichever. I assume the students have had a chance to argue, different sides of the case, but anyways, but I have taken a position in this case.
And also, Randy, Corey is coming to South Texas on March 30th. Is that the date, Corey?
Yes. I think so.
So we're doing an event, affirmative action, at our law school. Sorry
Good.
So he'll be coming here on March 30th. So you might
Yeah, they had a whole Daily Show little segment last night with Hassan Minhaj, who's Indian, and then Ronnie Chan, who's Chinese, and they got into a thing about who's the real Asian American, and Ronnie was sort of saying, "Oh well, you're Indian, you're not a real Asian American," et cetera. And it was very funny because it is the overall grouping. That's a vast area, and there are total differences between subgroups of Chinese or Korean or Pacific Islanders or Pakistani or Indian or whatever. It is a wide range of different cultures and different backgrounds. And when you lump them all together into one group, it's just nonsense.
Very good. All right, good. Well, that's all I have. If the students can please sign off, I'll confer with the judges for a bit. We have another round coming up in about 8 minutes. But thank you so much. We will notify your coaches by the end of this week who will be advancing to the round of 4. But if I don't talk to you again, congratulations. You're all very bright and you have very promising careers ahead of you. So I'm very proud.
Thank you.
Thank you.
Take care.
Okay. All right. And then Kelsey, you're off after this one, but Corey's with you for
Yep.
another round.
Okay, well, have fun.
Thank you so much. And just put your grades in whenever. And I
I'll
will
put my grades in right now.
Yep. And I will see you.
These kids were amazing. These kids were.
The first two were really
both
sharp.
groups were just
Yeah.
to me amazing in the
Yeah.
level of preparation for high school kids. You get really good kids, or they're trained well in the program, or some combination. It's really impressive.
I'm blessed. These students, they're self-selecting. Not everyone, you know, a lot of the coaches have a number of teams, but some that just really up their game and they increase from round to round. They get better.
Right. Yeah, well, I understand why you like participating in this and spending the time and effort, because it's fun to work with kids who are that engaged. It's always fun.
Awesome.
To do that.
These kids could come to our law school and compete in a moot court
Oh,
competition.
no question about it. All
All right.
right. Well, I'll put my scores in. And
Yeah, I'll see you, Corey, in about 10 minutes. Okay.
Okay.
Actually, 7 minutes now. Thank you.